Well, I think mediation offers huge advantages. And when one considers that in the context of litigation, you can see that there are a lot of benefits to be gained. Perhaps first I could talk about the advantages of mediation generally, and then bring in international mediation. As far as general mediation is concerned, if you look at court litigation, very often the parties are left on the sidelines. And the case takes a momentum of its own. It's controlled by the lawyers and by the processes of court. And the parties, generally speaking, will leave the conduct of the case up to the lawyers. And so they don't get a real say in the matter. They're always acting on advice. And the possibility of settlement becomes more and more remote as the case goes on and becomes more contentious. Nevertheless, most cases are settled. The problem is that they are settled just before trial when all the costs have been incurred. So what mediation does is really to bring the parties together, and I believe to put the lawyers on the sidelines. The lawyers are still important in mediation because they're advising their clients. But really the mediator's role is to bring the parties together and to help them achieve the resolution of their dispute. And as far as international mediation is concerned, it's probably more advantageous simply because there are more differences when you have international parties. One party in one country, one party in another country. You have different cultures, different languages. And so when you bring them together in a room, you have to bridge the gap. Hopefully the parties will understand a common language, which would normally be English. But even if they don't, we can always have the assistance of translators or interpreters. But it's a wonderful way of actually getting the parties together and to see what they really want from the matter. I realize that different mediators have different styles. I myself believe that all styles can come into play depending on the circumstances of the case, the nature of the dispute, the character of the parties. So if you have a case where the parties are in a state of hostility towards each other and they're not willing to talk, and that could undermine the mediation, it's important for the mediator to take the initiative by bringing parties together. If necessary, by talking to them separately, by informing them that it's really important that they get together in the joint session. And in that context, the mediator is playing a more authoritative role in order to get the parties together. Then you have circumstances where the parties are actually very happy to talk to each other. They use the mediation forum as an opportunity to speak. And in this case, the mediator plays less of a role, and he facilitates in the true sense of the word by ensuring that the channels of communication between the parties are open, and to clarify when necessary, to summarize any conclusions, to assist the parties in their communications and the generation of options. Then there may be other circumstances where the parties are not actually aware of the reality of their positions. And this might require the mediator to become evaluative. In other words, to tell the parties that in a polite and diplomatic manner, that if they go back to court, then perhaps their chances are not as good as they think they are. And this is where the legal skills of the mediator are particularly important. And just to show the parties that perhaps their perspective is not complete.